USCIS just issued a new policy memo that is causing major concerns in the immigration community. The memo says that applying for a green card from inside the United States, known as adjustment of status, is an extraordinary discretionary benefit and not something automatically granted simply because a person technically qualifies. Hi, I'm Muhammad Amir. I'm an immigration attorney and founder of Amir Law Firm. Today, we are going to break down what this new USCIS policy actually means and, equally important, what it does not mean. Before I start, let me remind you that this channel is dedicated to provide you with immigration news and information. Make sure to subscribe to our channel. Also hit the bell icon so you can be notified as soon as a new video is posted. So naturally, people are asking, is adjustment of status dead? Are marriage-based green cards now at risk? Will USCIS start denying more cases? No, adjustment of status is not dead. But green card cases inside the United States may now face significantly greater scrutiny. First, and this is critical, you can still file Form I-45 inside the United States if you qualify under immigration law. This memo does not repeat Section 245. Congress still permits many individuals physically present in the United States to adjust status to permanent residency. So despite what you may hear online, this is not a ban on adjustment of status. The law still exists. The eligibility rules still exist, and many applicants remain fully eligible. So what changed? USCIS is essentially reminding immigration officers of something that has always existed in the law. Technical eligibility does not automatically guarantee approval. INA 245 states that status may be adjusted, not shall be adjusted. That language matters. Adjustment has always involved two separate questions. First, are you legally eligible? And then, second, should USCIS approve the application as a matter of discretion? The new memo places far greater emphasis on the second question. USCIS basically telling officers, look beyond eligibility. Evaluate whether the person deserves these discretionary benefits. That discretionary principle is not new. USCIS wants officers to apply it more aggressively. Who may be most impacted? This is where the memo becomes important. The biggest concern is likely for people who entered on temporary visas, were originally expected to depart, later overstayed or violated their statuses, and then pursued a green card from inside the United States. Particularly B1, B2 visitors, ESTA enter, F1 students, TN visa holders, J1 visa holders, people with lengthy unlawful presence, or cases involving possible preconceived immigration intent. This memo will likely lead to more RFEs, more interviews, more discretionary reviews, and potentially more denials where officers believe the person misused a temporary visa or circumvented normal immigrant processing. Immediate relatives of US citizen, biggest question. This is probably the number one question we are getting. What about spouse of a US citizen, parents of US citizens over 21, and unmarried children under 21? Under INA 245A and 245C, many immediate relatives of US citizens remain suitably eligible even if they overstayed, worked without authorization, or fell out of status. That law has not changed. So if someone was inspected and admitted on parole, many immediate relative cases remain legally viable. That's extremely important. However, USCIS officers may now scrutinize these cases more closely, including intent to enter, immigration history, prior violations, misrepresentation concerns, and discretionary factors. So immediate relative cases are still alive, but likely harder. What if someone entered legally, but is now out of status? This is where many marriage and family cases fall. Example, someone enters on a tourist visa, later overstays, then marries a US citizen. The memo does not eliminate eligibility, but USCIS may now ask, Did this person truly intend to temporarily stay? Was the visa used consistently with its purpose? Why is adjustment being pursued rather than consular processing? Are there favorable equities supporting approval? This becomes especially important in cases involving recent marriage after entry. Quick filing, repeated entries, or inconsistent statements made during admissions. Again, eligibility may still exist, but the discretionary review may become tougher. Dual intent visas, important progression. Now let's talk about something very important. The memo appears to recognize dual intent principle. This matters tremendously. Visas such as H-1B and L-1 already permitted immigrant intent under immigration law. That means an H-1B or L-1 holder pursuing permanent residency generally should not face the same intent problems that may arise with tourist students, ESTA, or TN visa holders. For many H-1B and L-1 cases, adjustment remains strongly defensible. What about E-2? E2 becomes more trickier. Unlike H1B and L1, E2 is not fully dual intent. E2 requires intent to depart when status ends. Having said that, that does not make new processing impossible, but USCIS may examine provide representations, timing, immigration strategy, and consistency more carefully. So E2 cases may receive a greater scrutiny than H1B or L1 cases. What about pending cases? Another major question that we are getting. If my case is already filed, the memo does not expressly exempt pending cases. Practically speaking, USCIS officer adjudicating pending cases will likely apply current guidance. So yes, pending cases may be affected, especially where interview remains pending, discretionary concerns exist, or immigration history is complicated. But a properly filed pending case is not automatically denied because of this memo. Should everyone switches to consular processing? Not necessarily. This is where individualized legal analysis becomes critical. For many applicants, departing the United States may trigger 3-year bar, 10-year unlawful presence bar, waiver complications, administrative processing delays, or also risks. For many immediate relatives already eligible under 245, adjustment may still be strategically stronger than leaving the United States. There is no one-size-fits-all answer here. Best strategy going forward, defend the case. This may be the most important practical takeaway. Memo does not stop people from filing. So the focus becomes how do we defend discretion? Going forward, strong adjustment cases should proactively document positive equities and good faith and credibility documentation. Discretion and credibilities are becoming front and center. So what's the bottom line? This memo is significant, but it is not the end of adjustment of status. The biggest change is likely more scrutiny, more discretion, more RFEs, and greater focus on intent and equities. Strongly documented cases, especially immediate relatives, H1B and N1 holders, and individuals with lawful admission and compelling equities should still remain viable. But weak, rushed, inconsistent, or poorly documented cases may become considerably riskier under this administration. If you are considering marriage-based green card, employment-based green card, family sponsorship, adjustment of status, or have a pending immigration case, you should seek individualized legal advice before making immigration decisions. At Amir Law Firm, we are actively monitoring this policy and advising our clients worldwide. For guidance, you can book a consultation at our website, www.amirlawfirm.com. Policies like this can shift rapidly. Stay informed. Subscribe for verified immigration updates from Amir Law Firm, where law meets clarity. Thank you for watching, and I will see you in my next video.